webinar is being recorded. We're going to be doing business in an uncertain world, where Jayne is going to go first, and then Neil is going to take us through his various slides and the issues on that. So if you'd like to ask a question, that would be very much welcome. Please use the Q&A box. You don't have to give us your name, but if you don't do so and we don't answer a question live, it means we can't come back to you with an answer later. Whereas if you do give us your details, we can. There will be, in the tradition of these, a feedback form which will pop up as you leave at the end. Be really grateful if you could complete that for us. At certain points, I might pop back up during the presentations and ask what are amazingly either naive or particularly on-point questions, and we'll see how we get on with that. But I'll try and deal with questions at the end to make sure we run to time. So we're going to be out definitely by 11, and we might be out earlier, but that will depend upon the engagement we get from you, the audience. So without further ado, I'm going to hand over to Jayne, and she's going to start us off on doing business in an uncertain world. Thank you, Jayne.
Thanks, James. So for those of you who don't know me, I think a number of you will, my specialism is supply chain contracting. And it is quite interesting to me how my work changes depending on where we are in an economic cycle. So I can talk to you more about that as we go through. So this term, a VUCA world, has been around for a while, basically to describe the volatile, uncertain, complex and ambiguous world that we live in. And I think everyone will agree that the last 3 years have certainly been volatile and uncertain. And there is no end in sight to all of this volatility and complexity. So what are we seeing? We are seeing, of course, significant economic volatility, not just in the context of the aftermath of the Truss Kwarteng mini budget, but there are other factors having a significant economic impact. Energy costs, of course, being one. Actually, the costs associated with COVID and the aftermath of dealing with those costs, and actually volatility, economic volatility caused by trade tensions. We, of course, have got political and social volatility, the war in Ukraine being a very obvious example, but equally there is other political volatility that we are facing. For example, the trade tensions between the US and China. And indeed, the UK's relationship with China is, I think it's fair to say, less than stable at the moment. We also have natural disasters, a lot of those, of course, associated with climate change. I mean, we saw the terrible flooding in Pakistan a couple of months ago. But when I was looking at this, I sort of came across this statistic whereby I hadn't appreciated 23% of the world's population now live in areas prone to significant flooding. Now, of course, that's a huge human disaster, but in the context of supply chains, you imagine a situation where you have almost a quarter of the world's population at risk of serious flooding. Imagine the supply chain disruption that can cause. But of course, what all of that means is supply chain decisions that were once considered very sensible and appropriate can quite quickly become unviable. And so that's what I want to sort of talk around this morning. So Claire, if we could go to the next slide, please. What does all this mean? How does it manifest itself? Well, of course, one of the obvious things that we are seeing in supply chain contracting is material and component shortages. Of course, the automotive sector, the tech sector is very affected by the issues with semiconductor shortages. We are seeing labour shortages, not just skilled labour shortages, but actually less skilled labour is also in short supply. We're seeing supplier capacity constraints caused by many factors, including component shortages, but also caused by energy issues. We're seeing delivery logistics disruptions. All of this, of course, adding up to escalating costs, and all of this bringing about financial constraints potentially on your supplier base, or indeed on you as a supplier. In the context of supply chain contracting and the importance of supply chains, sorry, Claire, next slide. I thought that it was a really good quote to highlight the importance and value that effective supply chain contracting and supply chain management brings to a business. It is about the success of a business being very much linked to the effectiveness of its supply chain. The graphic on the right, I have put here to just demonstrate that when you are thinking about the supply chain of your business and your involvement in contracts, the important thing for you is to see the supply chain in a holistic way, and therefore to understand where what you are working on or being asked to advise on fits in with the entire supply chain. So understanding the knock-on of one supply failure on the rest of the supply chain. I think in a volatile environment, having that understanding to make sure that you are approaching your supply chain contracts in the right way is actually crucial. So what does this mean for lawyers? Claire is reading my mind now, which is great. Thank you, Claire. What does it mean? How can we as lawyers help our organisations? How can we as private practice lawyers help your organisation? But importantly, how as you as in-house lawyers helping your organisation? Well, the first and obvious in the context of supply chain contracting is the contracts you draft, you review, you negotiate, and the different things in those contracts that you have to focus on or pay particular attention to, which I will talk about more in a moment. But the other important piece is encouraging active contract management when a contract is in place, and active supplier or customer management when in the supply chain. So let's turn to the first element, which is contract drafting. Next slide, Claire. I thought it would be helpful to set out some of the areas that I am seeing increased focus on at the moment. And I think when I was thinking about this and preparing for this, I thought, well, actually, fundamentally, what this all boils down to is flexibility, flexibility, flexibility. You're seeing that from the customer side of things, but also the supplier side. So I'll just pick out a few of these areas. So firstly, exclusive or a non-exclusive contract. Now, if we wound back a few years, customers would quite happily give a supplier exclusivity and indeed minimum volume assurances in return for better pricing and more favourable payment terms. Actually, what we're seeing is exclusivity for a supplier is now hard won. Exclusivity is not being given that often, and if it is being given, it is being given with a lot of sort of exit routes from exclusivity from the customer's perspective. However, that does depend on the product or service, but particularly the product that's being supplied. For example, if you have a product which is subject to lots of regulatory approvals, the fact that those approvals exist may actually force an exclusive arrangement because getting the approvals is so difficult in a dual or multi-source situation. But generally, we're seeing a lot more dual or multi-sourcing approaches. In terms of volume assurances, we are seeing customers say, we just do not know what our demand is going to be like. We think it's this, but next month it might fall off a cliff. And interestingly, I've just been working with an overseas business who had contracted with a logistics provider on the basis of certain volume assurances, and that gave them better logistics pricing. The market for their products, which I suppose what we might call discretionary purchases fell off a cliff, and suddenly they were in a position where they just could not satisfy the volume assurances, and it looked like they were going to end up with a contractual penalty payment. Interestingly, the question from the overseas business there was, "Oh, is this sudden recession a force majeure event?" To which the answer was, no. You would not interpret a force majeure clause in that way unless there was a very, very specific reference to a recession in a particular country. So, but again, the point there is customers very cautious about volume assurances. Equally, the flip side is, though, suppliers are quite nervous as to giving assurances as to the volumes they are able to supply, quite often because they have uncertainties themselves in the context of being able to get the raw materials, being able to get components and so on. So that is quite interesting to see that change. What it means is what you're seeing in terms of contract drafting are, to the extent there are volume assurances, the ability to change those. Now, there's an interesting piece here because, of course, suppliers will also say, well, in order for me to be able to deliver in accordance with the lead times you want, I have to place material purchase orders. So one thing we are seeing is customers and suppliers actually talking to each other a lot more, with the customers understanding, okay, I now understand that you have to place orders on these material suppliers by this time, these component suppliers by this time. And you're seeing more cooperation and a more sophisticated approach on contract volumes, with the sort of rolling forecasts, which are non-binding, an element of binding, but very informed by the nature of the supply chain. The other thing that we are seeing, there's a bullet point at the bottom there, information and collaboration, is the customers and suppliers working together to try and solve supply chain difficulties. Again, if you wound back a few years, you may have found a customer saying, actually, that's your problem, sort it out. I have a contract on at the moment where it has been discovered that the customer also has relationships with some of the supplier's supply base, and the customer has a lot of purchasing power. And what the customer is doing is helping the supplier to work with that part of their supplier base to try and resolve supply chain difficulties. So that is quite interesting, that there is more of a collaborative approach to solving difficulties, because it is recognised that on the whole, the difficulties are not being caused by suppliers being lazy or not bothered or ineffective. It is caused by market conditions, and so there is more of a willingness to work together. I've sort of already touched on lead times and service levels. In terms of delivery commitments and lead times, what on the whole we're seeing is suppliers building in what I call a lot more wriggle room in the context of their delivery commitments, and also there being a lot of escalations in service levels before somebody is considered to be in default because of delivery delays. So again, another example of how at this current time the market's changing. On pricing, I think it's fair to say it's not very often at the moment that you see fixed prices in contracts for any length of time. If you do, what you will also tend to see at the moment is a number of price escalators. So circumstances where a supplier is able to come back and point to increased costs to increase the price, or open up a pricing discussion. Again, I've got one on at the moment whereby the sourcing is from a range of jurisdictions, And so one of the price trigger points is when CPI in these various jurisdictions hits a certain point, and that can happen. That is ad hoc, so it's not annual, it's not quarterly, it's just when CPI hits these trigger points. From a drafting perspective, the one thing I would say here is if you're looking at those escalators, make sure you think about the correct reference point indicator, because it is not necessarily the case that RPI or CPI are the correct reference points. It really depends on what the product is, what the materials that are in the product, for example. So on metals, you might find that your escalator is linked to prices on the LME, for example. I think I've already touched a little bit on risk allocation. The point with risk allocation is, again, we're seeing a more nuanced and sophisticated approach because of the uncertainties in the market. So we are seeing risk put into different buckets, depending on whether it is market impacted or not. And an example, I suppose, which I've already given is around the risk of late deliveries, whereby there are quite a lot of escalation factors before a series of late deliveries would trigger a material breach or a contract termination. So if you are relying on, so if you're using service levels, they also become more sophisticated in the context of trigger points for a contractual penalty, for want of a better word, or a breach circumstance. Just another point to raise: duration and exit points. Of course, you know, being ever the optimist, we all like to think that market uncertainty will be short-lived. I think the reality at the moment is we don't know whether that is the case, but therefore what we are seeing is the ability break opportunities, and those break opportunities may be because a market is no longer viable, but also, of course, it may be when economic circumstances ease and the volatility eases, you might want to break because you might be in a position to negotiate different terms and more beneficial terms. When you're thinking about your duration and exit points, just also, I always remind people, please do think about the consequences of termination, what you need to happen on termination in the context of any stocks of materials, in the context of tooling and intellectual property. So I think I've covered off most of the key sort of legal terms that we are seeing in the context of this volatile market. Claire, can we flip on now, please? I now want to turn to the second point that I said I wanted to touch on, which is properly managing supply chain contracts. And when I was thinking about this, I cast my mind back to 2008 and was recollecting that in the aftermath of the financial crisis, actually my supply chain contracting work became quite different. And a lot of what I was asked to do at that time was clients coming with long-term contracts saying, actually, we're losing margin. What's in here that we can use? What you saw was that ultimately the contracts hadn't been properly managed, and therefore the businesses had lost their control or influence over that supply relationship. They were suffering in terms of their margins. In some cases, there was a brand damage implication, but of course, as we all know, the issue with supply contracts not being managed properly is there are implications in terms of legal claims, and ultimately the business and we as a collective group of lawyers end up spending our time helping with crisis management as opposed to actually taking the business forward. So it is, I can't emphasize enough the importance of properly managing supply chain contracts at the moment. Claire, can you just flip on for me? Thank you. So, again, casting my mind back to 2008, one thing I uncovered with a sizable business that was involved in long-term engineering projects was that they had, over the life of the contracts, implemented a number of contract changes, and they had incurred costs to make the contract changes, which had been requested by the customer, but nobody had invoked the change control process, and therefore nobody had taken the opportunity to say, but making this change costs X and Y. This is an impact on the price. And it was a really sort of shocking tale, if you like, on how much money you lose when you don't manage in accordance with the contract terms. So if you were being asked to look at your existing contract portfolio in the context of how we can increase price or renegotiate or save costs, here are just a few things for you to think about. So where does the contract give you the ability to renegotiate? So renegotiate terms, renegotiate the price. Are there price escalation mechanisms that need to be invoked? And if you can invoke them, how do you invoke them? Are there benchmarking provisions, either for your benefit or the supplier's benefit? What are the service levels, and are they fit for purpose? Are there opportunities to lever off the service levels? And ultimately, can you terminate? You may be being asked, we need to exit this contract because it is simply not economically viable for us. So understanding rights of termination, which of course you can also use as a lever for renegotiation instead of actually terminating. But think about what rights can you use and what cost saving opportunities are there in the existing contract. I think that brings me to the end of my slot. Just though concluding remarks from me is, in the context of supply chain contracting in this volatile market, just be prepared and encourage your business to think about prevention being better than cure, both in the context of the contracts that it's entering into, but also in the context of actively managing the contracts. And also, appropriate internal systems and controls are really important, both in the context of managing the contract, but also in the context of managing your supplier or customer base, and indeed the financial stability of your supplier and customer base. I think on that note, it's now time for me to hand over to Neil.
Before we go with that, thank you very much, Jayne. From a supply chain basis, we moved to doing business in an uncertain world from an insolvency basis. Jayne, I'll come back to you. There's a question all about, is there a source for looking at things like CPI, RPI? Can you have a look at that, and I'll come back to you at the end for that? That's all right.
Yeah.
Neil, over to you.
Thanks very much, James. Good morning, everyone. For those that I've not presented to before, my name is Neil Smyth. I'm a partner and national head of the Restructuring Insolvency Group at Mills Reeve. I'm going to talk for about 10-15 minutes on the three items on the topic slide in front of you. The first two I'm going to talk very briefly about. Myself and my colleague Morgan Bowen talked to one of these sessions in the summer around insolvency procedures and the steps that you can take to protect your position to the extent that one of your counterparty ends up going into one of those insolvency procedures. So for those that attended that session, you'll be glad to hear that I'm not going to rerun that all again. But I will briefly remind those who've seen the previous session and also educate hopefully those that didn't attend the session in the summer. But the main event is going to be talking about how, if you have those rights, how you actually assert those in an insolvency process, some of the tricks of the trade, etc. So Claire, if we could go to the next slide. Briefly, as I say, these are the main insolvency procedures that you are going to come across. Some I would suggest more than others. We have two new insolvency procedures that came into force back at the start of COVID, the moratorium and restructuring plan. Moratorium is effectively a process whereby the directors continue to run the company, the UK's version of US Chapter 11, which has been thoroughly unpopular so far. I think there have been in total about 40 processes in the last 2.5 years, and not all of those have actually got approval. So it is unlikely you're going to see moratorium procedures, and probably unlikely on the numbers that you're going to see company voluntary arrangements or restructuring plan schemes of arrangement. They tend to be used in bigger restructurings, but they are effectively where debts are compromised at pence in the pound in an effort to ensure the survival of the company. What I'm going to be talking about mostly today are administration and liquidation. Those I think are likely to be the most likely processes you're going to come across. Administration creates, as for those that have attended these sessions previously, a moratorium, which prevents enforcement, and that is obviously a main theme when you are looking to enforce your rights against a company in administration. Liquidation does not necessarily do that, but is a terminal process and generally results in a low return to creditors. So that's a very quick run through what could be a presentation in itself. Claire, if we could move to the next slide. But as I said in my topic slide, what is, why do this? Why have contractual protections in place? Or alternatively, answering that question, or answer that question, when do I recover? That's what it's all about. When do I get my money back, to the extent that the counterparty goes into an insolvency process? And that is the waterfall of recovery. Where you want to be is up the top. Where you don't want to be is down the bottom. Where the vast majority of creditors are is down the bottom, second last entry, unsecured creditors. And therefore, for example, if you are able to be granted security, you could elevate yourself very much from the bottom of the pile up to the top, depending on the nature of the security that you are granted. Two things to watch out for that have changed in the last year or so. The biggest change is preferential creditors, actually now 2 years tomorrow. HMRC has been a preferential creditor for the last 2 years, and that has greatly affected the ability for all of those creditors below preferential creditors on that waterfall to recover, particularly floating charge secure creditors. Because as you can imagine with COVID, there have been business failures and there has been an uptick in non-payment of tax. And therefore, those two combined factors mean that HMRC are submitting to very large claims in insolvency processes at the moment, which is deflating down the ability of all classes of creditors below them to recover. The general rule on an insolvency process is that if you are an unsecured creditor, you should probably expect to recover very little, if anything at all. Those prospects are not recovering. And that, in fact, is the answer to the question, well, why would I attempt to put some kind of contractual protection provisions in there? Because I don't want to be an unsecured creditor. I either want to be higher up that waterfall, or I want to take some other means to try and ensure that I get my money back, or at least a higher proportion of my money back, than simply being an unsecured creditor. So that's what it's all about. So Claire, next slide, moving on to the main course. So I'm not going to talk about how you create these rights. I've talked about that in previous sessions, but what I'm going to look at today is, if you've got those rights, then how do you actually enforce them in light of the different insolvency processes that you might come across. So firstly, let's look at security and those provisions that you might insert in a contract whereby you are retaining possession of assets but not actual title. I've touched on security already. Two forms of security that you would tend to find in a standard debenture. Fixed charge, as you may remember from the previous slide with the waterfall, that is where you want to be. That is the ultimate protection that you can have in an insolvency process if you have fixed charge over a company's assets and that company goes into an insolvency process, then you are top of the tree. Those assets effectively fall outside the estate. The general costs are not taken out of those assets, albeit that the costs of sale of those assets, the insolvency practitioner would be entitled to take. Having said all of that, if you do have fixed charge security and the company that you're dealing with goes into administration, then you will not be able to enforce that security without the consent of the administrator or an order of the court. Now, that whether the administrator will consent will really depend on the circumstances. If the asset is a standalone and does not affect the value of any associated business, then it's likely that the administrator will consent, because ultimately, if the charge holder goes to court, they are going to get that order and they're going to get a cost order against the administrators. However, if the asset is very much part of the business proposition, then the administrators may argue that the ability to sell it as part of the wider business will enhance value for all creditors, not just the fixed charge holder, and therefore that would be a reason not to consent. Having said that, flipping it around the other way, the administrator, because the asset effectively falls out the estate, can't enforce without the consent of the fixed charge holder. So it runs both ways. But if there is the ability to obtain fixed charge security over fixed charge assets like property, it's certainly one that should be taken, because at the very least it gives you enhanced right of recovery and a seat at the table in relation to any negotiations as to exactly how the insolvency process is proceeding. Floating charge, as we saw on the previous slide, is down bottom middle in relation to the recovery waterfall, and with HMRC's preferential claims, floating charge recoveries are now less. So there is less ability to control the sale of assets. The security can be released, certainly by an administrator, and also liquidated without consent of the floating charge holder, and therefore its use really is in relation to initiating an insolvency process on the borrower rather than making a recovery. Liens, process by which you retain possession over goods, if that is your business and that is how you are seeking to protect yourself in relation to the insolvency process of a counterparty. As I will say a lot, to the extent that the counterparty goes into administration, again, you can't enforce your lien without consent or court order. But to the extent that you are holding possession of assets that are key to a business, and I certainly acted for a client that did that in relation to a mobile phone provider a few years ago, pre-Christmas, holding thousands of Apple iPhones, you are suddenly in a very good position. And often the issue is not so much around the quality of the wording of your lien. It is more the fact that you are severely disrupting the business flow and the ability of the administrator to trade and sell. And therefore, it can be, in the right circumstances, a very good way of leveraging your position and recovering, even though, as a matter of law, you can't enforce, but you can certainly stop the administrators from taking stock out. To the extent that you have or are offered some kind of trust escrow arrangement, as I've said previously, the absolutely fundamental point here is that those arrangements are only going to be worth entering into if you have a situation whereby, as a matter of law, the assets are owned by you or a third party rather than the company going to an insolvency process. If they're owned by the company, then ultimately you are not going to get the protection that you need. And in addition, if they're owned by the company, if you're trying to enforce those arrangements, you're going to be caught by the moratorium in any administration. If those assets fall completely outside the ownership of the company, then you won't have any bar to enforcement, because they're not company property. They are your property, or they are third-party property. So when you're putting those arrangements in place, you need to think very carefully about, is it clear who owns these assets? And if it's clear that the company still owns those assets, then that is not really achieving what you're trying to achieve with those arrangements. So Claire, next slide, please. Contractual rights. Jayne's talked about termination, and that is not something that is prevented by the moratorium. So there is the ability to terminate, but I think, as Jayne has touched on, effectively, if you've got the right, is it the right thing to do? And what is the timing? I'm currently acting for a client who is talking a lot about termination, but actually that is in the context of a business that has gone into administration where the administrators are not able to continue to trade. So I think there has been some concern that if they don't terminate, the administrators may turn around and say, well, we've done work for which we want to be paid. But the reality is generally both administrators and liquidators will not continue to perform a contract unless they know they're going to get paid for it. And that involves often payment up front from the other contracting parties. So termination might be the right thing to do, and you will be free to do it if you want. But is it the right option? What consequences is that going to have on the rest of the contract in relation to your claim in the insolvency process or anything else surrounding the relationship that you have? As I've said previously, probably the most important contractual provision that you can have is set off. If you have that, there is insolvency set off. There are some fairly convoluted rules around the ability to set off an administration, but if you have contractual set off, then what you have is the ability, obviously, to set off what you owe against what you are owed. And I've talked about if you are owed money as an unsecured creditor, then that claim is probably worthless. But what you want to avoid is a situation where you have to repay a debt that you owe to a company in an insolvency process, only to receive very little, if anything, out of that money back. So it is a very strong right. It doesn't constitute an enforcement of rights and therefore doesn't fall foul of the administration moratorium, and it puts you in a much stronger negotiating position. So as I've said previously, if you have no other contractual protection in your contracts, and hopefully you would have some of these other provisions, but if you have nothing else, please ensure wherever possible and wherever suitable that you do have a set-off right, because it is going to be invaluable if a counterparty goes into an insolvency process. You may have a guarantee from a third party. That should not be affected by the company's insolvency process. You are enforcing against a separate legal entity, and therefore, if the obligor has gone into an insolvency process, you should be free to enforce that guarantee. If for some reason you have a guarantee that is only conditional on conditional recovery affected by the obligor's insolvency process, then that is a guarantee that you should not have entered into in the first place. But that would be a very unusual circumstance to arise, but it is something worth checking if you are being granted guarantees as part of the protection you're seeking. So Claire, if you could move on to my last slide. Probably the most common provision that is used in an effort to protect against counterparty insolvency process is retention of title. Again, in relation to enforcing any retention of title rights, if the company has gone into administration, then the moratorium will prevent the creditor from enforcing those retention of title rights to the extent that they actually want to go and move their goods from site. But of course, that is not the whole story. From a legal perspective in establishing a retention of title claim, you've got to identify the goods, and then subject to that identification, you've actually got to demonstrate that the clause is incorporated in and it actually works and it's valid. But you don't get off first base with a retention of title claim unless you can actually identify your kit. So there is no point getting into the weeds of the legal niceties of whether your clause is incorporated in work, to spend 2 weeks doing that, to establish that with the administrators, to then get on site and find that all of your stock has disappeared because it's already been incorporated into other products or it's been sold off. It's absolutely key, if you have a retention of title claim, that you identify the goods over which you assert that claim as soon as you possibly can, or at the very least put the administrator on specific notice that you have a retention of title claim and over which kind of goods. The administrator is an officer of the court. They are regulated. If they try and pull a fast one, then there are routes to complain about their actions. But what they don't have to do is simply sit there in stasis, anticipating that there may be a retention of title claim over goods, and therefore not process, not sell. Their job is to act in the best interests of creditors. If they're trading a business, then they will want to get on and do it. So it really is up to you. If you've got a retention title claim, you need to put the administrator on notice of that claim as soon as possible. Get down there, get identifying of the kit that you have supplied. don't get fobbed off. The moratorium does not prevent you from identifying, it just prevents you from removing. So if the administrator's like, well, you know, I'm not sure I can do now, how about next week, how about 2 weeks, you know, get down there as soon as you can. It is often in a pre-packaged administration situation that a purchaser might have bought the goods, you might be referred to the purchaser. Okay, that might be fine from an identification point of view, but ultimately the legal position is still with the counterparty, it's not with the purchaser. The purchaser might be prepared to do the commercial deal, but if they're not, your contractual right is with the company in administration or liquidation. So enforce your rights politely, but do that as a matter of urgency, because that is 99 times the killer of retention of title claims, is simply the failure to identify the goods that you're claiming over. Lastly, if you are an unsecured creditor, you can make a claim in the administration. That is not supposed to be a complicated process. You don't need legal advice to do it. Lawyers can help you if needs be. Any moratorium by the administration will not prevent you from doing that. But as I say, repayment is unlikely, and therefore that really is a process. The other rights that I've talked about are going to be the routes from which you can make recoveries to the extent that your counterparty goes into an insolvency process. So hopefully that is helpful in taking the conversation the next stage forward from a practical point of view. I will return to James to deal with the questions.
Thank you very much. So what I take from both of those excellent presentations is, one, get your contract right in the first place. Two, manage the contract through the duration of the contract, so you are talking to your supply chain people. Three, if things go belly up, absolutely have a set-off clause as a minimum in it, and then be very careful about how you can identify your goods if you're looking at retention of title, and hopefully you'll get a fixed charge at least, because otherwise you're going to get basically nothing. Is that a fair summary, Jayne, Neil?
Yes, I think so. Move quickly would be the key. Know what your rights are and how you need to actually go and assert those as quickly as you can.
Okay. I was going to do that in the style of Greg from Taskmaster at the end of every Taskmaster program, but decided that may not be entirely appropriate for today's audience. But and it relies on you watching Taskmaster, so you know, perhaps niche. Jayne, we had one question, which was: is there guidance, a link that you're aware of, to understand which reference point is to be relied on when considering certain price and indexation? At times there are queries around if it should be CPI, RPI, and other indices. Did you find an answer?
Right, it's a really good question, because I think the point being made by the person who asked the question is exactly right. RPI and CPI may well not be the appropriate index. There are some other indices. So you've got things like the producer prices index, wholesale price index, you've got an employment cost index, export price index, import price index. However, what you need to do is actually look at what is being supplied and what goes into what is being supplied. And the other honest answer is that we as lawyers don't need to have a detailed understanding of that in the way that the purchasing team do. So my honest answer is, if I were working on something, I would be asking a very direct question of the purchasing team as to what is the correct indice here. Are you really sure it's RPI or CPI in the context of what is being, what the inputs are into the product? And or I might ask for finance to have an input into that question. Okay. The other point of, so, you know, there are particular reference indices for energy. Equally, you have the London Metal Exchange. If most of the inputs are metals, it will be different if it's dairy. It will be different if it were a sugar-based product, for example. So there isn't a one-size-fits-all, and nor is there a one big list of all of the indices. And the reality is, I'm not sure they would be that helpful unless they actually listed, if your product is this, this is the index you need, if you see what I mean. But just a few other observations, of course, as well as product dependent. Also, the other question is where the sourcing is coming from. So I think I mentioned earlier, I've got something where the inputs are coming from various jurisdictions. So actually, we have to look at indices across different jurisdictions to work out escalators. And in that case, as it happens, CPI is the right indice to use, but we're using CPI in 3 different jurisdictions as a trigger point. So when CPI in any of these jurisdictions hits 7%, it automatically triggers a price review. Don't forget, of course, at the minute we're all very focused on prices going up, prices for everything going up, but at some point prices will come down. So these price adjustment mechanisms do need to work both ways. What else did I note when I was thinking about this question? The other thing to understand, again, this is really something for the purchasing team, but the extent of forward buying by the supplier. Because if the supplier is actually forward buying all materials, then it wouldn't necessarily be right for them to be able to trigger a renegotiation if an index hits a certain level, because they're not affected by it. So that's just another thing. But again, I think this is where legal and purchasing and sometimes finance have to work really hand in hand to reflect the reality, rather than sometimes what happens, and I'm sure this will be familiar to lots of you, where purchasing or whoever have done what they consider their job and then they throw it over the wall and say, okay, so just draft the contract. I do think that in the current market, legal and purchasing, legal and supply need to be working really hand in hand to make sure they are getting the terms exactly right and thinking about the different permutations. So I'm sorry I'm not able to point you to an encyclopedia that gives the absolute answer, but I hope that gives you some pointers on factors to think about when you're considering the relevant reference indice, because you are quite right, CPI and RPI are not necessarily the appropriate indices.
Okay, thank you very much. Oh, and an answer, thank you, it does help. Well, there we go, Jayne. Brilliant.
Okay.
Thank you for the response. Right, in the absence of anything else, I think we should say thank you to Jayne and thank you to Neil. If we were in person, that would be followed by a round of applause. So just assume you've had a round of applause from the remaining participants, you too. Thank you, everyone. Right, as you leave, people, there will be a pop-up feedback request. Really grateful if you could say something nice, and if you can't say something nice, think about carefully what you are going to say. We do appreciate all constructive criticism. We will see you next time. Thank you very much for joining our in-house advisors forum, and season's greetings for the upcoming festivities. Thank you, everyone. Take care and goodbye.
Thank you.
Thanks, folks. Bye now.
Bye.